I'm going to get mic'd up here. Just a little bit on my background. My wife and I owned a ranch in Arizona for about 30 some odd years, and we sold it several years ago. We were partners in with some family members. Is that better? Oh, okay, for the recording and all that. So I've been on both sides of the fence, so to speak, as far as my familiarity with the ranching business and with working for the federal government. I have 16 and a half years with the federal government. Most of that was with USDA. The biggest part of that was with the U.S. Forest Service, but I also worked for the NRCS and I worked for the Bureau of Land Management. So I'm familiar with all of these various federal agencies. When I first started working for the Forest Service, of course, I have to say that, you know, I felt like I was more predisposed to being favorable towards ranchers because that was our background. But one thing that I did find was that the people that worked for the Forest Service, for the most part, there were a lot of them that had been loggers before, they'd worked in mining, or they had some experience growing up in the West. But as time moved on, more and more and more of these people were, I guess, what we might call outsiders. You know, maybe they grew up in Pennsylvania or something. Everything they know about wildlife they learned out of a book in college. And so then they'd show up and they'd start trying to tell this rancher, oh, no, you're doing everything wrong. You don't know what you're doing. Okay? And somebody had asked before about the situation where Forest Service employees move around. They move around a lot and they don't want them to get to know the people. I think there's a lot of truth to that. And they don't really relate to the small town rural culture that we have. But I want to give you a little history about our country and about the land disposal laws. And that's the title of this talk. Western Land Disposal Law, Understanding Split Estate or Multiple Use Rights and Jurisdiction. And you've heard this term multiple use. You've heard the term public land. There's a handout that's going around. The first thing in that handout is a court case, a court decision called Wilson versus Cook from 46, I believe. And that case is all about jurisdiction. And it's dealing with a national forest. There was a guy who bought timber, and there was standing timber. Now there's several other things in this handout. That's just one of them, that one case. There's also, I'm writing a book, and I put the unedited first version of chapter 1, which is called What Are Public Lands? Now, I've thought about this. I don't have a whole lot of money on me, but you know what? I'll give 20 bucks to anybody that can give me right now the legal definition of the term public lands. Any takers? Wait, one at a time. Who wants to try it? Do you know what the legal? Okay, there you go.
Weren't these just basically the unsettled portions of the lands in the West, especially?
Lands held in trust.
Unsettled or unclaimed, either under the Homestead Act, otherwise.
Boy, you're pretty close. I might owe you 20 bucks.
The public part of this, I mean, the term public tells me that the lands don't belong, as they put it, to the Forest Service. They belong to the public of the United States, which happens to be a registered public.
Give me some more. I want to.
Legal registered public.
Well, you know, you're pretty close, but there's some important things left off there. And there is a legal definition of the term public lands. A lot of people don't realize that. Some people would throw national forest or grazing districts or national parks, would throw them into this category of public lands. But the fact is, those are not public lands. And there are Supreme Court decisions on this. And it's very, very, very important to understand what is and is not public land. And the reason is because there are certain laws that apply only to public land. And when a rancher goes into court, like Wayne Hage and his family, and you know what? Wayne Hage gets Sr., who is deceased now. I met him back around 1989, 1990, and we became very good friends. Even though I was working for the Forest Service at the time, we became good friends. His book, Storm Over Rangelands, really got me to thinking about this idea of split estate lands. Okay, now the euphemism that Congress has used for split estate land is the term multiple use. Okay, multiple use, which is really several different uses of a piece of land, and in real estate terminology it would be called split estate. Okay, where maybe the timber rights might belong to one person, a surface right of some kind might belong to another, there could be an easement, timber rights could belong to someone else, and over time Congress has granted certain rights to people. And in the beginning, and let's see here, let's start with this map here. I did not create this map. This map was produced by the Bureau of Land Management. Okay, this is an official government map. The name of it, Federal Public Land Surface and Subsurface. Okay, now that should be a clue right there to this concept of split estates, where the government could own the surface estate, it may own the subsurface estate. There could be various interests. And as we go through this, I'm going to show you in the law what the definition of public lands is and has been from the very founding of our country on down. Now, after the Treaty of Paris was signed in 1783 to end the Revolutionary War between the British and the colonies, which were now states, what happened was there was a confederation, the Iroquois, or the Northwest Indian Confederation, that inhabited this area, kind of from here down to the Mississippi River and north of the Ohio and south of the Great Lakes. Okay, this area was inhabited by Indians who had treaties with Great Britain. And the Indians did not want these colonists settling in this area, and because there was a big fur trade between the British and the Indians. This was called the Northwest Territory. Okay, now at the signing of the Treaty of Paris, everything east of the Mississippi that England claimed, there was some area down here that was claimed by the Spanish, which took in Florida and over to here. So there were several other ancillary agreements. But in 1783, the war with England stopped. But there continued for another 10 years, 12 years actually, till 1795, there continued to be a war with the Indians in this area. And it was a pretty bloody war. It was called the Northwest Indian War. Okay, this is historical fact. You can go back and look this up. But until they signed the Treaty of Greenville with the Northwest Indian Confederacy, there continued to be fighting because they did not want these colonists, which were now an independent country, they did not want them moving into this area. This was the very important hunting grounds to the Indians. George Washington and his Secretary of War, Henry Knox, developed what they called the reservation and assimilation policy of the United States, which has continued down to today to be the policy of the United States. Everybody has this, and I'm going to ask you if you will hold your questions at the very end. We're going to have a question and answer session. If you have a question, write it on a piece of paper. Don't forget it. If I don't cover it during, we're gonna go for an hour, take a break, come back, go for another hour. Then we're going to have questions at the end. So if you would write your questions down, otherwise I won't get through all of my presentation. But I just wanted to mention that. But I wanted to say that as the federal government moved farther west, acquiring different areas of land like the Louisiana Purchase, which took in most of about 15 states. Okay, that doubled the United States in size when that happened. Then again, when Texas was annexed, its claimed territory went all the way up into Wyoming, kind of like this, down along the Rockies. But when they were annexed as a state, they gave up this area farther to the west. So we acquired Texas, the Southwest, which was mainly this area about in here, took in California, it came across here. That was in 1848 with the Guadalupe Hidalgo Treaty. 1846, the Northwest Oregon Territory Treaty, which took in actually even part of Montana, but Idaho and Oregon and Washington. That was a treaty signed with the British. So the United States, between 1845 and 1853, the United States doubled again in size. So, I believe it's, I want to say 1905, somewhere around there, it might have been 1908, Louisiana Purchase took place, and we acquired this area of land, basically, and then doubled again in size between 1845 and 1853. So here's the United States. It's expanding in size of territory, but how many Americans actually lived in this area? How many Americans actually lived in this area? There weren't a whole lot. The only way the United States could hold that territory was to populate it with people who were loyal to the United States. So they had to make some promises. They couldn't tell somebody, okay, go out west and settle, but in 100 years, we may change our mind and we'll take that land back. No, they had to have a set system set up where people could go out, settle on land, and have some guarantee that their investment of time and energy would pay off. But they also had a treaty with the Indians to begin with. And they said, okay, we have to figure out a way where we can reduce the bloodshed and warfare. So for the first time in the history of the earth, here was the United States, an expanding country, and instead of exterminating or kicking out the existing people that were living here, the Indians, George Washington and Henry Knox came up with this reservation and assimilation policy. And the policy was that if the Indians wanted to abandon their tribal way of life and as an individual become an American citizen, then they could take up 160 acres under the preemption laws just like any other settler in this area. And those that did not want to give up that tribal association, the government would sign and negotiate a treaty with them and establish a reservation, which would be forever theirs. Okay, and this is in the Indian Commerce Act of 1796. Okay, so you can look that up. This is just plain historical fact. This is the way the government was settled. This was a pattern that was set from early on. So, property rights. Now these settlers wanted to move out west. They wanted to have some guarantee that their investment of time, of years, would result in them being able to acquire a legitimate property. Now, here we are back to this question of what are public lands, because you could only settle on public land. Now, public land is land that is open to entry and settlement. If it is not open to entry and settlement, it is not public land. This is the definition used by the courts. It's not found anywhere in the Constitution, the term public land. And this became an issue around, a couple of decades after the Revolutionary War and the signing of the Constitution. This didn't really become an issue till then, because there's plenty of space for people to go out and settle. And Congress was just kind of trying to work out what is the best way that we can settle all this land. And originally, it was strictly by purchase. You'd pay $1.25. Congress sold, one sale was authorized by Congress of over 1 million acres to a real estate, basically a real estate development company. And so they would buy this huge amount of land, and then they would parcel it off and sell it to people as they move farther west. That was the original intent. But the problem was, here you've got these Indians that are highly resistant, and they're fighting, saying, no, you can't come in here. So when they finally settled the war and signed the Treaty of Greenville, they came out with the Indian Commerce Act of 1796 and said, all right, this is how things are going to be. We're going to use this assimilation and reservation policy. And we're going to establish reservations for those that don't want to assimilate, to be landowners and own their own land. And that is where the whole reservation system that we have in the United States started. Okay, so what constituted public land was, as this gentleman was saying, unoccupied land. But it also had to be open for entry and settlement. So it had to be unoccupied. No one could have any claim to it. If you came out and settled on 160 acres here in Idaho 140 years ago or whenever, you came out here and you settled and you marked out, staked out 160 acres, the very moment that you moved on to that piece of land, it was no longer public land. Even though the title had not yet passed to you from the federal government, the Supreme Court, and the government as a whole over the 240 years of our history, that land ceased to be public land. Why? Because now someone had a claim to it. It was no longer unoccupied, open land available for settlement. Someone else had already settled there. And if someone tried to claim that land, that's what we're called claim jumpers. Okay? So this is important to understand how this whole system of land disposal occurred from the very beginning. And it's been very consistent. It was this right of occupation. As soon as you occupied that piece of land, you marked your boundaries, you lived on it, you started to improve it, it was no longer public land. Now, I've seen a lot of people go into court and they've tried to claim, well, Your Honor, I have a right to whatever on public land. There are no rights on public land. Public land is just this wide open, no one has any rights attached to it, piece of land. That is public land. If it's claimed by someone, what Congress called it in the acts of Congress, where someone has moved onto the land and established a claim, it's called occupied, unpatented land. It's not called public land at all, because there is a definition of that term public land. And there has to be, because in the courts, if you go into a court of law and you're accused of doing something that's illegal on public land, a court can't make a decision if there isn't a defined meaning of that term. If you got pulled over for recklessly operating a commercial motor vehicle, and that's what the statute said, reckless operation of commercial motor, and you're driving your private vehicle, or can you be charged under that law? No, because it's not a commercial motor vehicle, it's a private. There is a legal definition, and there has to be in the law. And from the very beginning, this term public land has had a defined meaning. So, let me back up just a minute. So what are property rights? This is the concept that has ran consistently through all of the land disposal laws of the United States. And this was written by a gentleman by the name of John Locke. He's one of the two most quoted individuals by the founding fathers in the Congressional Globe, which was the forerunner of the Congressional Record in the history of our country, in the founding of our country. This is one of the philosophers quoted, one of the people that was quoted most often by the founders, and his second treatise on government, which was published in 1776, and this is what he said: though the earth and all inferior creatures are common to all men, yet every man has a property in his own person. This nobody has any right to but himself. The labor of his body and the work of his hands, we may say, are properly his. Whatsoever then he removes out of the state that nature hath provided and left it in, he hath mixed his labor with it and joined to it something that is his own, and thereby makes it his property. It being by him removed from the common state nature placed it in, it hath by his labor something annexed to it that excludes the common right of other men. And basically what he's saying is, 120 years ago or whenever here, if you had arrived here and you said, I'm going to settle on this land, and nobody was living here, nobody was occupying it, and you went out and you cut down a bunch of trees, nature provided that. God, nature, it's there. You mix your labor with that resource. You have cut those trees down, you've limbed them up, you've skinned the logs, you've notched them, you've stacked it up. You've now mixed your labor with that object of nature. You have tilled the ground, you have planted a garden. Now you have mixed your labor with this part of nature, and you have created property. You have mixed a part of yourself with that object of nature. And this is the concept of occupation and settlement that governs all the land disposal laws of the United States from the very beginning. So, how did we end up with all this then? Okay? I'll tell you how. All right, from the very beginning of the United States, there was a land classification system. Land was classified as agricultural or mineral. Okay? Agricultural land was land that could be cleared, it could be planted, and it would produce a crop. Now, in this part of the United States back here, basically everything is agricultural land. There's only a very few places that would be considered mineral land. Okay? And the agricultural land laws had one set of requirements in order to acquire the land. But mineral land, almost from the very beginning, was habitually retained by the federal government, especially if it had any kind of military or national value. And one of the first cases to address this, we'll probably get to it in a minute. But as settlement progressed westward, they started to get into more of these mineral lands. When you reach the 100th meridian, which runs right here, you got past that 30-inch rainfall zone, you couldn't grow crops without irrigation. And so now the line between agricultural land and mineral land became more blurred and not as clear. So in the early days of the United States, there were vast amounts of lands west of the Appalachian Mountains claimed by some of the states and tribes. Some of the states refused to sign the Articles of Confederation until the other states gave up their claimed western territories for the mutual benefit of them all. And so this resulted in Article 4, Section 3, Clause 2 of the Constitution, okay, which says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory and other property belonging to the United States. And in this case of United States versus Grayshot, 1840, the U.S. Supreme Court said that this clause, the Constitution, talking about territory and other property, referred to the public lands. Those were the public lands. The territory and other property belonging to the United States. So do not confuse it with, this is, as a matter of fact, this is called the property clause. This is referred to as the property clause. On the other hand, you have the enclave clause, which is Article 1, Section 8, Clause 17. And that's what a lot of people like to refer to when they say, oh, the federal government can't own land. It can't own land in a state because it says that the Congress shall have exclusive legislative authority over 10 miles square, which shall be for the seat of government, and shall exercise like authority over all places purchased with the consent of the state legislature for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So there are a lot of folks that feel like, oh, well, the federal government can't own any land. Well, that's not what it says. It's not talking about land ownership. Article 1, Section 8, Clause 17 is talking about jurisdiction. Exclusive legislative authority. That's exactly what it says. Now, if this was just me making that claim, well, you could challenge me. But this is the analysis of the U.S. Supreme Court in a case called United States versus Texas, 1950. But it's been addressed at least 6 times by the Supreme Court over the history of our country. Okay, so this idea that the federal government, whoops, I'm going the wrong way here. This idea that the federal government cannot own land was answered early on. Okay, in this case of U.S. versus Grayshot, because this dealt with mineral land. And who has the power to dispose of the public land? Congress, not the president, not the Secretary of Interior or anybody in the executive department. Congress alone. And the reason is because they did not trust a president, a single individual. They'd just gotten rid of a king who would dispense land titles to his favorite citizens or to his friends that helped him in war and would give him large land grants. They only trusted this power to Congress because they knew Congress would be the most fair in deciding how that land was to be disposed of. And this is discussed in this case, United States versus Grayshot. And if you have a problem with accepting that there's a difference between the enclave clause and the property clause, read U.S. versus Texas. And I'll give you a place to look. Write down Justia, Justia, justia.com. It's a free legal website. You can look up the case of United States versus Texas, 1950. And the Supreme Court goes through step by step and explains how the Enclave Clause has to deal with jurisdiction, and that equal footing has nothing to do with ownership of land. And they explain in there, they say that if you, in that case, U.S. versus Texas, they talk about Texas and the equal footing doctrine. They say the state of Texas was a republic before it joined the United States. It was not formed out of territory that belonged to the United States, unlike all these other states were. They said the state of Texas was an independent republic just like the original 13 colonies, that when the 13 colonies signed the Constitution, they gave up some of their power. They were no longer independent countries or independent states. They joined together. They delegated certain powers, like the power over the regulation of interstate commerce, the power to coin money, the power to make war. Okay, those things they gave up. They gave up some powers. They were no longer this total independent republic. Okay, but they said Texas was just like these states. And so when Texas joined the Union, it did the same thing. It gave up certain of those powers under the Constitution that were delegated specifically to the federal. Now that case was about ownership of who owned the oil offshore within the outer continental shelf. Okay, that's what that case was about. But the state of Texas was arguing the equal footing doctrine, the Enclave Clause, and the Property Clause, and the Supreme Court explained step by step the difference. And they said that under the Enclave Clause, which has to deal with jurisdiction, Article 1, Section 8, Clause 17, they said that the Enclave Clause dealt only with political authority, and that Texas had the same political authority as every other state, and it had nothing to do with ownership of land. And the fact that the federal government owned this undersea land, the outer continental shelf where this oil was being drilled, did not deprive Texas of any of its sovereignty. They said that if ownership of land had anything to do with equal footing, then Texas would never be on an equal footing with a state like New Jersey or Connecticut or Massachusetts, because they don't have nearly as much land. So equal footing has nothing to do with land ownership, is what the Supreme Court said. Okay, so you can read that case. If you feel otherwise, that's fine. I'm not trying to change your mind. I'm just telling you what the Supreme Court said. Okay, to help you to understand how this whole situation came about where the federal government, now the policy, I'm going to say this up front, the policy of Congress up until 1976 was disposal, land disposal. Okay, just like it says, Congress shall have the power to dispose of. But in this case, the Supreme Court said, well, if Congress decided, and this case was about mineral lands, lead mines, which were as strategically as important to the United States back then as uranium is to the United States right now. Because you make weapons out of uranium. You made bullets out of lead. And so these lead mines that the federal government, that the state of Illinois was arguing over, saying, you can't own those lead mines. We're a state now. We should own that. And the Supreme Court said, you're wrong. Okay? They said the United States has this, the Congress has this power to dispose of the territory and other property. And just because Illinois became a state did not mean that it automatically owned the land, everything in that state that had previously, the day before, belonged to the federal government. Because Congress has this power to dispose of. And the fact that they retained ownership of those lead mines for a strategic federal purpose did not deprive the state of any of its jurisdiction. And as the handout that we talked about, or that I gave out, that's got that Wilson versus Cook, talks about jurisdiction. It has to deal with a national forest and the timber, and you're going to see as I go through this how these split estate property ownerships came about. How Congress disposed of certain rights and interests while retaining others. But that case, Wilson versus Cook, deals specifically with timber. I think I'll save that and talk about that a little bit later. We're going to go ahead and go forward. So you see how this happened. This Lockean concept, this John Locke's concept, the idea of settlement, appropriation, possession. The reason I have all these words in quotation marks is these words are used repetitively over and over again through 240 years of land disposal law. This was a consistent, highly consistent way of disposing of the land to people who went out, occupied the land, improved it, settled on it, lived on it, and made it theirs. Now, in the very beginning, Congress charged anywhere from $1.25 to $2.50 for the land, which even back then was considered a relatively cheap price. But as they got farther and farther west, the land was less valuable. And so there are a lot of places where, you know, in Idaho, no offense, it's the same in Arizona, there's some land around here that 100 years ago wouldn't have got $1.25 an acre. You probably could have got a nickel an acre for it. But anyway, there's a whole, people think of land disposal only in terms of agricultural land. 160 acre, 320, 640 acre homesteads. Okay? But Congress, by various acts, such as the Organic Act, Forest Service Organic Act 1897, specifically say that these acreage limitations only apply to agricultural land, not to mineral land. And that's important because as people began to move farther and farther west, they were settling on these mineral lands. Okay? Remember this? These are mineral lands out here, not agricultural. Okay, and there was a whole different set of land disposal laws for mineral lands. One of them was passed in 1853 because what happened in 1849 in California? Gold. Okay, people were swarming west to settle. Okay, Congress had just, as I told you before, between 1845 and 1853, in an 8-year time period, they had acquired a huge, almost half the United States. All Texas, Colorado, New Mexico, all these 11 western states, okay, part of anyway. Montana, part of Montana was acquired through the Louisiana Purchase. Well, it's kind of like that. Okay, so they wanted in 1853 everybody all over the world's heading to California to look for gold. Well, how many Americans were actually living out here? Not a whole lot. They wanted people who would be loyal to the United States to settle out there. And if you read any of the homestead laws, every single one of them say any person who's a citizen or has signed a affidavit saying that they're going to become a citizen could settle on the land. And so that's how all these Germans and whoever from Europe came over. They might have stopped in New York City, but they kept going west, okay, in order to acquire a piece of property. So they made it very easy under these homestead laws to be able to acquire land, you had to live there for 5 years. You had to occupy, that was the word, occupy the land for 5 years. And that goes all the way back to 1795. The first law Congress passed to give land to French settlers who had been loyal to the United States during the Revolutionary War. They gave a big chunk of land in southern Ohio, with the only requirement being they had to live on it for 5 years. They figured after 5 years, you've fulfilled this concept that John Locke espoused about mixing your labor with the land, improving it, residing on it, building a residence and living on it. Okay, I wanted to change things up. Instead of starting at the beginning and going all the way to the end, we're just going to jump ahead. We're going to skip to the chase, as they say. This is Title VII of the United States Code. I mean, not United States Code, of the Federal Land Policy Management Act, excuse me. I doubt anybody in this room has ever actually read this law, because it is not in the United States Code. You cannot find this in the United States Code. This is only referenced in a few places in the United States Code as a footnote. But this is the most important section of the Federal Land Policy Management Act. And there's a good reason that it's not in the United States Code. Let me explain something. There's the Constitution, there's a hierarchy in law in the United States. The United States Constitution, the statutes at large, which are the actual acts passed by Congress, voted on, and signed by the President. That's the statutes at large. Below that is what's called the United States Code. The United States Code is actually written by a bunch of lawyers who work in what's called the Office of Law Review Counsel. That sounds weird. That's nowhere in the Constitution, but that's who writes it. What they do is they take every new law and they say, okay, let's look at the old law and let's see where it fits in, and we're going to wordsmith it to make sure it harmonizes, because the courts do not favor what's called a repeal by implication. If there's two laws that look like they're conflicting, their job is to try to interpret them in harmony. And so they write what's called the United States Code. You can look this up. This is a fact. This is the way they do it. Okay? I gave the same presentation to the Energy and Natural Resources Committee staff people in Washington, D.C. about 4 or 5 months ago. I thought this would be kindergarten to them. They already knew all this stuff. They didn't. They didn't know this. They didn't know this law existed. One guy told me, well, wait a minute, because I changed this around. I had Flipma at the end because chronologically that's where Flipma comes in. But right after I made my presentation, explained all these land settlement laws, the head staff guy says, well, didn't Flipma repeal all those old laws? They don't, I said, well, yeah, Flipma repealed all those old laws, but also grandfathered them in. As of October 23rd, 1976, the Federal Land Policy Management Act grandfathered in every existing split estate property right that Congress had granted over the previous 200 years. And this guy didn't even know Title VII of Flipma existed. But this is the actual law. The United States Code is not the law. The statutes at large are the law. Okay? But this is what the very first section says. Nothing in this act or in any amendment, that should be made. What is that, made? Made by this act shall be construed as terminating any valid lease, permit, patent, right-of-way, or other land use right or authorization existing on the date of approval of this act. That's the very first section. Here's something you guys are going to be interested in. notwithstanding any provision of this act, in the event of conflict with or inconsistency between this act and the acts of August 28, 1937 and May 24, 1939, insofar as they relate to management of timber, I need to move that down. It says that these latter two acts, these two, will take precedence. Those two acts are sustained yield management acts, which guarantee economic, trying to think of the way it's worded, the economic benefit to the communities. There's over 40, there's 43 exactly. There's 43 pages of law of Title 1 through 6 of FLPMA that come before this. Title 7 is 4 pages. What comes after this is listed one by one, all the various provisions of law that are repealed by FLPMA. And here's FLPMA saying that notwithstanding anything in the previous 43 pages, that means the previous 43 pages don't matter. If there's a conflict in the previous 43 pages of this law and these two laws right here, which guarantee economic production to local communities, those two laws are the controlling law. But because the average person does not know this, and you know what, I've been to Washington, D.C. several times, met with people in the Department of Interior, and I can tell you, they know this law. But their concern is with the jobs of the people they have working in their agency, not with you. The agency comes first. And here's these staff people on the Energy and Natural Resources Committee, and they've never even heard of this before. When you talk about a deep state, there really is. When it comes to the BLM and the Forest Service, those are career employees of those agencies. When I worked for the Forest Service, I confronted my boss one time, not really confronted him, but just questioning him, showed him a copy of the decision of U.S. versus New Mexico, U.S. Supreme Court decision, saying that ranchers own the water rights in national forests. And I showed that to him and I said, don't you believe, here's the Supreme Court saying ranchers own the water rights. And he says, well, we think the Supreme Court is wrong. And another time I asked him, I said, well, why don't we just acknowledge that these rights exist and just deal with it? And he says, we have jobs to protect. So this is the attitude that pervades in these agencies. So Congress entered treaties or agreements settling Indian claims, then enacted statutes for disposal of public lands. Because in this Indian Commerce Act of 1796, you could not graze on Indian land. You could not herd cattle. It actually says cattle, horses, mules, or stock to graze on Indian lands. So until the title of those lands was settled between the Indian tribes and the United States, that land was not public land. It was not open for settlement. But once that title was settled and the title to the other land was extinguished, now it became public land. And now it was open to settlement. Okay? So by public land, this is a Supreme Court decision, Barton versus Northern Pacific Railroad. This was 1892 case. Supreme Court said, by public land, as has long settled, is meant such land as is open to sale and other disposition under general laws. All land to which any claims or rights of others have attached does not fall within the designation of public land. So when you go in to talk to the BLM or the Forest Service, and they say, oh, you don't have any right on public land, you know what? Legally speaking, they are right. You have no right on public land. Okay, the real problem is it is not public land. A grazing district is not, quote, public land. Can you homestead in a grazing district? Is it open to homesteading? No, it is not. Can you homestead in a national forest? No. If you ever ask yourself, why not? Because someone else already settled there. It's called a grazing allotment. That is a real term, just like the term homestead. It comes from the General Allotment Act of 1887. Okay? So, public land, it's not public land if any rights of others is attached. It does not fall in the designation of public land. The policy to grant agricultural homesteads with an additional right of occupation cultivation on nearby mineral land. Remember, now there's places out west that are agricultural land, and that's where the homesteaders settled. Down along a creek somewhere where they could put water onto it and they could actually produce crops, and they took up 160 acres. But remember, there was also the mineral land laws. And after the United States acquired all this land, after between 1845 and 1853, they acquired all this land here. Congress passed an act in 1853 which granted a right of occupation and cultivation on the mineral lands. In other words, you only had a surface right. You could occupy it, you could cultivate it, and it was a right. And that's exactly what the language said, but not the minerals. And that's when this policy of retaining, and there's Supreme Court cases on this. There's also a Supreme Court case. I want to say it's 1950. I'd have to look it up. I've got it written down. I'll look it up in a little while. Are we getting close to an hour? How long have we been going?
53 minutes.
53 minutes. All right. So I got about 20 slides to cover in 7 minutes. So look fast. So when did public land? Whoop, I'm going the wrong way here. Okay. When did public lands become split estates? Okay, here again, the definition. This is the Supreme Court, 1987. It hasn't changed. Most enduringly, public lands have been defined as land subject to sale or other disposition under the general land laws. Okay, Utah Division of State Lands, this was another one of those states' rights cases where the state of Utah was trying to say, we should own the land. And here's the Supreme Court saying again, this is the definition of public land. Okay, because here's the real thing, the real reason that the federal government can't do this transfer of public lands that people are talking about is because these ranchers already have surface property rights. You would have to take away the individual rights, the water rights like Wayne Hage, the grazing rights, all these ranchers, all of the RS-2-477 right-of-ways, all of the ditch right-of-ways, all of the water rights that already belong to so many people all over the West in order to give these so-called public lands to the state. They really aren't public lands. There are rights already attached. Does that make sense? Okay, so between 1890 and 1916, Congress adopted a split estate land disposal policy. And you can look this up in this case right here is the most instructive. If you read all the footnotes in this case, the Supreme Court goes through and explains step by step how Congress adopted this split estate land policy. And it was based on the recommendation of Teddy Roosevelt in 1909 and his Public Land Commission. how are we going to dispose of, because by 1909, the West was basically settled. Okay, but there were still conflicts going on. And so they had to come up with some way to settle land titles in the West. And Teddy Roosevelt said, the only way we can do it is to create a split estate. Retain the commercial timber and the mineral rights to the United States, dispose of the service to the ranchers, the ranch settlers. And that's exactly what Congress did. Between 1899 and 1916, for 17 years, a new bill was introduced in Congress every year of how are we going to dispose of the grazing lands in the West. And it wasn't until passage of the Stock Raising Homestead Act that Congress finally decided, okay, we're creating the split estate. And you can read about this development in this case, Watt versus Western Nuclear, 1983. That's not an ancient case. That's not ancient law. At least to me. You know, maybe there might be some younger guys like Zach, like, I don't know, how old were you in 1983? You were 3, okay. All right, but if you want to, these acts and these 2 Supreme Court cases are very instructive. Okay, so you say, oh, Angus, that's just your interpretation. That's just your interpretation. Okay, well, let's read exactly what Congress said. And this is straight out of the Federal Power Act of 1920. And there's the reference, 41 Stat 1063. You can go to the statutes at large, look it up. And here's what the Supreme Court said. Public lands means such lands, and what did they add now? And interests in lands owned by the United States as are subject to private appropriation and disposal under public land laws. It shall not include reservations as hereinafter defined. Reservations means national monuments, national parks, national forests, tribal lands, embraced within Indian reservations, military reservations and other lands, and interests in lands owned by the United States and withdrawn, reserved, or withheld from private appropriation and disposal under public land laws. So that's not my interpretation. That's what the law says. Okay, so the next time you drive by and you see a sign that says, welcome to your public lands, guess what they're talking about? After 1920, public lands means interests in land. So what is available? Think about this. What kind of entry, if you can't make a homestead entry, what kind of entry can you make in a grazing district? A mining claim, or an oil or gas lease, or a timber sale. Because that's what the federal government retained. And that's why these ranchers have bought and sold and legally can, and the federal government has never challenged a single sale of any of these grazing allotments that have ever been made for the last 100 years, because it's a private property interest. Okay? And here it is. Here's the law, 1920, Federal Power Act. Public lands means, and I just read it. So, don't take my word for it. There it is. Now, you may not like it. You may not agree with it. But you know what? Who has the power to dispose of the public lands? Congress. So when Congress passes a law, dadgummit, that's the law. They are the ones who constitutionally have this power. So when Congress passed this law in 1853 that said if you go out west and settle and stay a loyal citizen of the United States, you have a right of occupation and cultivation on that mineral land. That is what's called a statutory grant. Some people say, well, where's your patent? Guess what? Congress can dispose of land any way they want. In the homestead law, you had to settle on the land, you had to live there 5 years, you had to cultivate it, you had to improve it, and then you had to file affidavits, then you had to pay $1.25 an acre, and then the Secretary of Interior was authorized to issue you a patent once you've done all those things. Or they can simply pass a law that says the right of way for the construction of highways over the public lands not reserved for other purposes is hereby granted. Which means it's granted. Okay, so they can dispose of land by either what's called a legislative grant, a grant in presenti that takes immediate effect, or they could have a long drawn out process that you have to go through. Have I got an hour? Why don't we you guys want to take a break, or you want to keep going? Okay, let's take a break for a couple minutes and then we'll start up again.